I have two guests in studio. We'll open the lines to you to ask the questions. I won't presume to, have the best questions leveled at some of our guests. We have two advocates. They have an understanding of the legal issues that have been raised, but it's not about prosecuting the merits or demerits of this case, but looking at the issues that have been raised and outlined for determination by the court during the pre-trial conference yesterday. And so we'll steer clear of merits and demerits, pros and cons of the various petitions that have been raised and even affidavits and responses too. So let's just quickly look at the 9 areas and issues for determination. And the first one being, did technology deployed by IEBC meet standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results? And the second issue that will be a focus, was there interference with uploading and transmission of Forms 34A from the polling stations to the IEBC public portal? Let's go to the third issue that is going to be considered for determination. And was there a difference between Forms 34A uploaded on the IEBC public portal, forms received at the National Tallying Center, and forms issued to the agents at the polling stations? That's a question. To the fourth issue of determination, and did the postponement of elections in Kakamega and Mombasa counties, Kitui Rural, Kateliba, Rongai, and Pokot South constituencies, and Nyaki West and Kwajenga wards result in voter suppression to the detriment of Raila Odinga and Martha Karua? We've spoken about that a bit with Dr. Ojwang here, and that's one of the areas of determination. The fifth being, were there explainable discrepancies between the votes cast for presidential candidates and other elective positions? Perhaps here we will have the issue of some people probably decided to just vote for one person or one political position. To the sixth issue of determination, did IEBC carry out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 138(10) of the Constitution? To the seventh and not least, did William Ruto attain 50% plus 1 vote of all the votes cast in accordance with Article 138(4) of the Constitution? And 8, were there irregularities and illegalities of such magnitude as to affect the final result of the presidential election? And 9, I see here a discrepancy in our issues raised. This is meant to read as 9. What reliefs and orders can the court grant or issue? So this is basically going to be the blueprint which they will be following. And even one of the issues in the orders that were given yesterday was on the polling stations, the results where the 15 polling stations, polling centers will be looked into, and not the entirety of it, just to see if it passes or fails the test of verifiability. So these are the issues we'll be canvassing and looking at with our two advocates in studio, and then jump to the Supreme Court with Duncan Khaemba, who will give us a contrast of the experience of covering this particular one and the previous presidential petitions, some issues arising in terms of differences, and even being the access to the service being granted to the petitioners. So, Dr. Ojwang, I'll involve you in one issue here as we move now to the particular areas of focus, and particularly this one being the concern that was raised by the Supreme Court. And I'm just taking from an article here from Capital by Jemima Mweni, just to give credit where it's due. And here, lawyers' parties warned against discussing merits of presidential petition outside the court. So, you know, from your legal background, what confines or what is a threshold of our discussion here, just to set the ground rules for us as we discuss it, because Justice Martha Koome warned lawyers in the presidential petition against discussing merits of the cases outside the Supreme Court. What about here, as we're talking on a case that is ongoing?
Right. Of course, you know, lawyers in the presidential petition most likely will avoid media at this point. The lawyers in the presidential petition at this point will obviously avoid media. And so I don't think it's a gag order beyond those lawyers on record in the Supreme Court. I think it is generally a good practice to give court time to determine issues, because, you know, media can sensationalize issue and can make a trial or hearing complicated, so that the focus of whatever happened to the courtroom is not interfered with from outside. Because if people are outside, and if there is much drama outside, and if there is much views outside, then it interferes with the fair rights and the fair hearing. But I think it's in the context of going foolhardy to talk to court and then again go out there and talk to the public. Some of it, you know, quickly spin to accusation on individual judges. What could be their possible reasoning? It prejudges. Some people could run, you know, the way maybe even newspaper have already summarized this as win versus losses. It already start making judges kind of get into the radar of the public and scrutiny before even their verdicts. But I think overall that must be balanced by the right to information, the right to canvass, the right to open society that is in Article 6 of the Constitution, and 10, that we live in an open democratic society. And therefore, yes, if a lawyer is on record in court, then obviously it will not be fair for them to go there and then come to the media. But I think that media have the duty also to inform the public and to contextualize the issues. And so I don't take it so hard that it means people cannot discuss what is going on and even cite the law out of court. Because you know, it's an open court. And that open means that court must also allow itself to be scrutinized by the public. Of course, understanding that they are working in difficult situations, they have not given a verdict, but everybody is being watched, including the judges. And I think they need to know that our public are not spectators, that judges do not become the law, they interpret the law of the people, and so the law belongs to the people. And therefore it is, to that extent, a partnership in terms of I've not come to your desk, I've not told you rule this way, I'm not going to sensationalize, I'm not going to put you and straitjacket you, but I'm also not just a bird in the nest who is opening the mouth and the mother just vomits some food on it. I'm also a rational human being who can look and contextualize issues.
And this